Good morning. Welcome to Wisconsin Supreme Court Matters, a webinar presented by the Madison Civics Club. I'm Joy Cardine. I'm the co-chair of the Madison Civics Club, which is a nonpartisan, nonprofit organization that invites notable guest speakers to address timely issues that are important to the civic health of the community and beyond. We also encourage youth engagement in civic life by awarding grants to school and community youth groups that are working on projects that would better society. And we will award one such worthwhile effort at the conclusion of our discussion today about the importance of the Supreme Court Justice election in Wisconsin. This program is being recorded and will be linked to our website in case you want to see it again or tell a friend who's not here today. Over the next hour, you will hear from three notable guest speakers who know a lot about elections and the Wisconsin Supreme Court and what's at stake. And we will welcome your questions for all of them. We will hear from former State Supreme Court Justice Janine Geske, UW-Madison political science professor Howard Schweber, and the executive director of the League of Women Voters of Wisconsin, Deborah Cronmiller. Please type your questions in the Q&A section, and I will present them to our speakers as we go along. But please note, our speakers are not here to give their opinions on each of the candidates, but to speak about the broader issues involved in this election. There are four candidates who are running for a 10-year term on Wisconsin's highest court. The two candidates who received the most votes in the February 21st primary election will move on to face each other in the April 4th spring election. Judicial elections are officially nonpartisan in Wisconsin, but partisan groups and individuals and issues and money are involved in the race, as the outcome will determine the ideological makeup of the court. Currently, conservatives have a 4-3 majority on the court, and one of the conservative justices is retiring. Two of the candidates on the primary ballot are considered or called conservative: former Supreme Court Justice Dan Kelly and Waukesha County Circuit Court Judge Jennifer Dorow. Two of the candidates are called or considered liberal: Dane County Circuit Court Judge Everett Mitchell and Milwaukee County Circuit Court Judge Janet Protasewicz. I got it. The Madison Civics Club does not endorse or support candidates or parties, and this webinar is not intended to tell you to vote for any particular candidate. But in the end, we hope that you will have a better understanding of the job of a Wisconsin Supreme Court justice, how the Supreme Court works, the importance of an independent judiciary, and the highly consequential issues likely to be decided by the next Supreme Court. And we hope to share with you information and resources to make an informed choice and encourage you to vote in every election, including the upcoming primary. We will hear from our speakers one at a time with some opening remarks, and then we will have a panel discussion, and we will include your questions. Let me welcome first former Wisconsin Supreme Court Justice Janine Geske. The Honorable Janine Geske was appointed to the Supreme Court by Governor Tommy Thompson in 1993. She won election to the court the following year. She stepped down from the court in 1998 to start her own alternative resolution practice and to teach. Justice Geske is also a distinguished professor of law at Marquette University and directs the law school's Restorative Justice Initiative. Her biography is a lot longer than that, but we only have an hour program today. Justice Geske, we are honored to have you with us. Thank you very much for being with us.
I'm happy to be here.
I was hoping that you could start us off by describing the job of a Supreme Court justice, what it entails, and the basics on how the Wisconsin Supreme Court as a body operates.
I'd be happy to do that. Let me just say two things about the court system generally. We have different levels of court in our state. We have municipal courts, and that's where if you get a traffic ticket or an ordinance violation, you're in those courts, and those are locally elected. In fact, those judges don't even have to be lawyers in Wisconsin. But the busiest courts in our state are circuit court judges, and they are elected By the county that they sit in, there are many judges around the state, and they are the front line of the judiciary. They hear all the cases, almost all the cases that come into our system. So everything from criminal to civil to family to estate, and some of the big systems like Milwaukee or even Madison have divisions, and judges hear certain specialties at certain times. That's where the trials happen, the jury trials happen. And then when and if a party loses in the circuit court, other than the state in the criminal case, the losing party has a right to appeal. And the appeal is to the Court of Appeals. And there are 4 districts in Wisconsin with Court of Appeals judges. And those cases have a right to go in front of those judges. So those judges, if you lost your whether it's your traffic ticket or your divorce or whatever the case is, you have a right, if you file timely, to have the Court of Appeals see whether the trial judge created error. And those opinions, sometimes are published, sometimes they aren't. And there are very fine judges all over the state. Those judges are elected for 6-year terms, as are the circuit court judges. Then we get to the Supreme Court. There are 7 justices on our Supreme Court. It's a constitutional court. It's created by our Constitution. And those judges are elected statewide. That's not true in all states. Illinois elects their Supreme Court by districts, but we elect them statewide. They are the final arbiter of law in Wisconsin. So if there's going to be development of law or a change of law or a finding of constitutionality that binds the state, it's going to happen at the Supreme Court. How do cases get there? Well, lots of people who are unhappy with the Court of Appeals opinion can apply, and we call that a petition for review. And the Supreme Court can or not take it. It's up to them. It's totally up to the discretion of the 7. And if you see a case accepted by the court, that only means, when it's coming from the Court of Appeals, that 3 of the justices think they ought to take it. So it's not a majority, it's only 3. And I just want to mention it because it's become more relevant. There is a way to bypass those courts. And that used to be very rare. If it's such a huge constitutional issue that needs to be decided immediately, sometimes you can file up at the Supreme Court initially. That takes 4 votes. And that used to be very rare, but it's happening a lot on our legislative kind of litigation and other kinds of litigation that's very controversial. And I think that's unfortunate. We don't have the benefit of the judiciary at the lower levels, but most of the cases have come through the Court of Appeals. So the justices look at the case, and what's the criteria? Well, it's really in the discretion of each of the justices. So each justice has a vote in deciding whether to take a case or not. And under the law, you're looking to see whether it's a unique issue, whether there's a conflict among the Court of Appeals, whether there's something that has to be re-examined because it's so old, it doesn't apply anymore. So it's really a cutting edge case that's going to affect the whole state. It's not supposed to be, I don't like the result that happened in Dodge County, and therefore I should have won there and now I should win at the Supreme Court. That's not the reason to take the case. So it's supposed to have wide-ranging effect. And frankly, many of the cases that the Supreme Court still takes are those cases, the cases that are big. So once the court has decided to take a case, then what happens is the parties start preparing the briefs. They can have amicus briefs. That's friends of the court. So if you've got a case that involves insurance law, maybe other insurance companies want to file an amicus or a friend of the court beat. You have a criminal case that has constitutional implications. Maybe the criminal defense bar wants to file something. So you get other briefs, but the parties brief, they give you the transcripts from the lower courts and you look at the briefs. So the Supreme Court does not take testimony, does not see the parties. They are not present in the courtroom. There are no juries. And so it really is a paper in oral argument court. And the court usually has oral arguments on that you can watch on Wisconsin Eye. They put out all the arguments of the Supreme Court. You can go back and look at Supreme Court arguments. They're very interesting because they will tell you a lot about particular justices and the kinds of questions they're asked. Then the court will eventually vote. And it votes on whether to affirm or reverse, but that's usually not the most important part of the opinion. The opinion is what the court writes in the opinion, how it affects all the other cases in the state of Wisconsin. and somebody randomly gets assigned the case in the majority. So you don't get the case if you're in the defense. So let's say it's a discussion and it's a 4-3. Well, the 4 are in sort of the pool of poker chips where a poker chip is pulled and one of those justices gets assigned the case. It's unlike the US Supreme Court where the Chief Justice assigns it. And that justice will work on an opinion, write an opinion. Some of them are quite long, circulate to other justices, and it can take a lot of discussion among the justices about whether they're going to join or not join or dissent. But ultimately, and it takes months for the final opinion to be issued, and that becomes the law in the state of Wisconsin. So I do want to just briefly mention that is not the only role of the court. It's obviously probably the most important, but the court spent a lot of time on court administration. What happens in our circuit courts? How do we have interpreters? What's the access to disabled? How do they conduct their business? I have to say that when I was on the court, we used to do our conferences. That is when we're debating rules, we'd be out in the open in the courtroom. Now they're back behind closed doors and the public can't hear what the debates are on the rules, not the law. The law is always protected. And so, you know, justices who are out in the community, who are working with community to build circuit courts, what happens in your circuit courts and even in your municipal courts, but your circuit courts is affected by how the Supreme Court rules. And so I don't want people to disregard the fact that how community-based those justices are isn't important. I'll stop there because I obviously can talk for a long time, but
some other important. Before I go on to our next speaker, though, Justice Geske, tell us why this race is officially considered nonpartisan, yet we hear in the media and elsewhere that the candidates are called conservative or liberal, and that the ideology or the ideological balance of the court is at stake with the outcome of this election. Can you explain the different judicial philosophies that would lead us to believe that a justice or a candidate is liberal or conservative?
You want me to do that in a minute or two?
Yeah, just a minute or two if you can.
Well, I like to think, I like to think of myself as someone with a judicial philosophy and not a political. A judicial philosophy can involve things like, I don't believe in reversing precedent, long-standing law, unless there's really been a change in circumstances or some reason that former case can't stand. I also don't think the court ought to be wandering into legislative things when they don't need to. The role of the legislature is very defined and clear as one of those 3 branches, independent branches of government, as is the executive branch. And the judicial branch, the question is how judges or justices see that branch and its role vis-a-vis the other 2 branches. What's happened unfortunately, and I'm very sad about this, in our races is we've gone from looking at candidates, or at least the headline being judicial independence, and looking at each case individually and looking at the law and determining what under the law and precedential and stare decisis or all sorts of theories the court ought to do, to a point where outside money, and we're going to talk about that because that's huge in this race. It's going to be the most expensive Supreme Court race in the history of the United States. Those have become very issue oriented. It's funny because it's issued not by the people who are spending the money, but issue for voters. So, you know, that you're tough on crime, you're not tough on crime. But that outside money has really almost directed candidates and pushed candidates into the political partisan world, in my view. And so you have candidates, and I think they've all done it to a certain extent, kind of tried to forecast what they're going to do in a particular case or a particular issue. That really distresses me, because when I walk into a courtroom, I want a judge who's going to look at the case anew and listen to everybody as it stands now and say, you know, what is the decision? But it has become partisan. The court has been certainly painted partisan. People can do their own evaluations. You know, people say, well, that's the conservative branch, the liberal branch. Is it philosophy? Is it partisanship? That's a determination people have to make. Partisanship should not be there, because if all you're electing is a Republican, conservative Republican, or a liberal Democrat, you might as well just have a bigger legislature and do away with the courts. I mean, those justices do not represent anybody in any partisan position. They represent justice under our Constitution, under the US Constitution, and under the law. And it's a problem. And every time I cringe with those camps, and I certainly use them because that's what's painted, but it's very unfortunate. And we really have to fight, I think, as citizens and voters to move away from that and really look at the qualities of each candidate and how they're going to be on the court.
Right. More later. Next, we are going to hear from UW-Madison political science professor Howard Schwaber, who's also a faculty affiliate member of the UW-Madison Law School. He was a regular guest with me and other hosts on Wisconsin Public Radio to discuss political issues, especially those issues involving the U.S. and Wisconsin Supreme Courts. It's nice to see you again, Professor Schwaber. Thanks very much for being with us.
Well, thanks for having me.
Why don't you give us an overview on why this officially nonpartisan race for Wisconsin Supreme Court justice seems anything but? What's happened?
Well, Justice Geske comments were so rich that I wish I could just comment in response to those for an hour or so. But let me dive in at the point where she left off about liberals and conservatives as justices. One of the things I try to persuade people, students, the public, whatever, is that there is a difference between what we call a liberal and a conservative judicial philosophy, but it does not map perfectly at all onto liberal and conservative policy preferences. And so there's a certain loss of meaning, a certain slipperiness in the use of those terms sometimes. That's different from genuinely partisan judges who really are carrying water for a party or for an issue or for a policy position, which can happen. But those two things need to be distinguished. I couldn't agree more with Justice Geske that the latter phenomenon, when you have justices who really are pursuing the agenda of, let's say, a party, the simplest possible case of one of the parties, that delegitimizes the court in a fundamental way. On the other hand, honest disagreements about judicial philosophy that may be characterized as liberal or conservative are perfectly valid. A quick bit of history. During the period when Justice Geske was on the court, I don't mean to single her out, Wisconsin business interests felt the court was anti-business, particularly in areas of product liability and some areas of labor law. And that led to an effort in the early 2000s to a very conscious effort to find politically partisan conservative candidates for the court. And really the non-partisan status of Wisconsin judicial elections ended in 2008, the election that brought Justice Gableman to the court. Starting then, we began to see large amounts of outside money. And more importantly, political operatives who had run legislative campaigns, now running judicial campaigns, specific and explicit efforts by party organizations to push the candidacy of one candidate or another. So I really think in Wisconsin in particular, the idea of nonpartisan elections has completely gone by the wayside. I'll mention that the Sofra Center at Harvard University did a study about 5 or 6 years ago now on what they call legal corruption, that is, extents to which judicial systems around the country have become politicized in the illegitimate way that I was describing. And Wisconsin was ranked as one of the worst in the country, which is a huge, massive turnaround from, let's say, as recently as the 1990s or the year 2000, when Wisconsin was widely regarded as having one of the clean government. We're not like Illinois, kind of thing, widely regarded as having one of the cleanest governments and one of the least partisan courts of any of the states. So there's been a tremendous capture of the process by political actors and political money that has profoundly changed the character of the of the electoral enterprise. In the current election, you mentioned that we have two candidates who are described as liberal and two who are described as conservative, but it goes a little farther than that. I'm going to look at my notes here because I do want to pronounce Judge Protasevich?
Protasevich.
My apologies.
I had to practice a lot.
Judge Protasevich and Judge Mitchell are both what you might think of as very middle of the road political liberals, if you want to, judicial liberals. For example, Mitchell is a Baptist minister with a master's degree in theology. So he's anything but a-religious. Just to take one example of a dividing line people sometimes focus on. And neither is known for particularly extreme positions or an ideological background that's particularly sharply defined. One went to UW-Madison Law School, one to Marquette Law School, mainstream Wisconsin educational institutions. Both Dorough and Kelly went to a place called Regent Law School, which is a law school associated with a college that was originally called the Christian Broadcasting Network University. That was actually its name, which is a terrible name, and I'm very glad they changed it to Regent. Founded by Oral Roberts. This is a law school and a university whose explicit mission is to promulgate evangelical Christian conservative views. So these aren't conservatives versus liberals exactly. This is what political scientists call asymmetric polarization. There's a great deal more polarization on one side than the other. And in this instance, our two conservative candidates are really very much from both ideologically and by training from the religious right, as opposed to American conservatism is a very big tent with many types of conservatives and flavors of conservatives. These two both come from a particular strain of American political conservatism, which is heavily religious and evangelical and quite hard-edged in contrast to the other candidates. So that will matter because obviously, I think, the biggest issue on the table for most voters is abortion. With the Dobbs opinion by the US Supreme Court, the issue of abortion rights has been given back to the states. And the makeup of the Wisconsin Supreme Court going forward, whether there's a 4-3 conservative pro-life majority, that is religiously conservative pro-life majority, as opposed to say economically conservative, or whether there is a 4-3 pro-choice, politically liberal majority, will make all the difference in the world. But that's not the only issue or issues likely to come before this court. I was looking at the docket, the cases that are currently pending. There are issues about police misconduct. There are issues about First Amendment. Certainly, one of the issues that ended any thought of the Wisconsin Supreme Court as being nonpartisan was the 2020 election, when the state Supreme Court became a direct participant in determining and influencing the outcome of the national election. Well, there are cases coming both this year and in future years, this coming year and in future terms, having to do with voting rights and voting practices. So there are really a wide array of issues. I didn't mention guns, everybody's favorite. There again, the US Supreme Court has opened the door to a very different kind of jurisprudence than which most of us have been accustomed to for our entire lifetimes. So there's a lot at stake, a lot of different things, of which abortion is only one, an extraordinarily important issue, of course, but abortion is only one of the many consequential issues that the court will face. And the distinction between the candidates is really extraordinarily stark. And so I'm pleased to see a large turnout for this event. I hope that presages a large turnout for the election. Ordinarily in off years, Wisconsin's judicial elections draw a turnout in the low 20s, 22, 23%. Regardless of one's views or which candidate one favors, I hope people will realize that a lot is at stake and turn up to vote.
So much to follow up on, but let's hear from our next speaker before we dive a little deeper. Executive Director of the League of Women Voters of Wisconsin, Deborah Kronmiller, joins us. In the spirit of full disclosure, I serve on the board of directors of the League of Women Voters of Wisconsin, so I know firsthand how hard Deborah and league members around the state work to defend democracy and to empower voters. The league, like the Madison Civics Club, is nonpartisan and does not endorse candidates or political parties. Deborah, thanks very much for being with us.
Thank you so much for having me and for hosting this important decision on the Supreme Court election and the court itself. Let me begin by sharing our vision for the courts. We envision a system where all people have equal access to fair, unbiased decisions, and where the courts are reflective of the people they serve and are insulated from the corrosive impact of partisan politics and special interests. The League of Women Voters believes in representative government and in individual liberties established in the Constitution. The League believes all powers of the government should be exercised within the constitutional framework that defines the balance among the three branches of government: legislative, executive, and judicial. The League believes that democratic government depends on informed and active participation in government and requires that governmental bodies protect the citizens' right to know by giving adequate notice of proposed actions, holding open meetings, and making public records accessible. The League believes every citizen should be protected in their right to vote. Every person should have access to free public education that provides equal opportunity for all. And no person or group should suffer legal, economic, or administrative discrimination. The League believes efficient and economical government requires competent personnel, clear assignment of responsibility, adequate financing, and coordination among the different agencies and levels of government. Today, we've already heard much about the importance of the Supreme Court in Wisconsin, and I want to reiterate that the founders likely did not imagine the environment we find ourselves in today. Today's court system has in many ways evolved to meet the unique needs of the people who will come before it, and by creating opportunities for diversion and treatment instead of incarceration. These are good changes. Some changes are not as good. Courts should not carve out courts that tip the scale of justice toward the powerful. In 2009, the League of Women Voters of Wisconsin petitioned the Supreme Court to instate ethical standards for all judges, including the justices of the Supreme Court. Our petition was denied. In 2009, we saw the need for more assurances from the corrosive impact of partisan politics and special interests. Remember, too, in 2009, the amount of outside political money in judicial races was a tiny fraction of the amount pouring into judicial races today. Dark money is threatening the fairness and independence of our courts. The League will continue to advocate for ethical standards and will also continue to ensure that all voters have the information they need to cast an informed vote. Though justices will have both progressive and conservative ideologies, cases should not be decided on these preferences, but rather on the law and the Constitution. This is why it's important to inform ourselves and vote in all judicial elections. This spring, as we do for all elections, the League will encourage voting and engagement in our democracy. We will publish the Vote 411 voter guide, so voters have information on the candidates in the candidates' own words. Voters can see side-by-side comparison of the candidates' qualifications and judicial philosophies and their preparedness to serve. The League will also empower voters by providing important information on the elections itself. What races are on the ballot, what the office holders are responsible for, the dates of the election, where the election will be held, where to vote, how to vote, whether that's by absentee ballot, early voting, or in person on the election day. Importantly, the League will also be there as nonpartisan observers, so voters know that the results of our elections are accurate and accountable, and that our election administrators have followed the statutes for free, fair, and accessible elections for all. On February 21st, we will all have the opportunity to vote for a new Supreme Court justice. We know how many of the freedoms that we have as Wisconsinites have come before the Wisconsin Supreme Court. Important voting rights issues have been decided in Wisconsin by the Supreme Court, including our state district voting maps, the use of drop boxes to return an absentee ballot, and the need for voters to show an ID in order to vote. Other important decisions beyond voting rights have also been made by the Wisconsin Supreme Court, such as weakening the workers' rights to unionize, the state's COVID-19 emergency orders, and many environmental protections and regulations cases. Many of the freedoms that we have as Wisconsinites could come before this upcoming Wisconsin Supreme Court. Important freedoms such as access to reproductive health services, gun safety and gun rights, LGBTQ+ rights, and more voting rights cases could all be heard by this court. Now is the time to make sure you are informed to vote, know how to vote, and are motivated to do so. Please contact the League or your clerk if you need any assistance to make your voice heard and have your vote count. Thank you, Joy.
Thanks, Deborah. And I know Deborah is going to share some resources in chat, so you can save those. We will also be posting numerous resources on the Madison Civics Club website after this broadcast. Let me move on to the issue of the money. Since Justice Geske brought that up in her opening remarks too, explaining that this could very well be the most expensive state Supreme Court race in the history of Wisconsin, in the history of the country, probably. Justice Geske, why is that so concerning to you? Oh, and we need you to unmute.
Sorry, I should know that by now. It's concerning for a lot of reasons. First and foremost, it is people and entities and groups outside of our state putting pressure on our voters and others to elect a candidate whose interests will align with their particular interests, whatever they may be. That's number one. Number two is that when I look at those ads, and I hate them as much as most people hate them, but yet they draw people into them and you form your views on candidates on those ads, is that the object of the ad is rarely the issue that the group was concerned with. So, for example, you will have terrifying ads of criminal, whether the rapists are walking around the street looking for your daughter, or whether you're going to get abducted, or you let somebody out on bail at one point. Those are all issues. They ought to be brought up, but it's not what the Supreme Court does. They don't do any of that work. What they do is the things we've already described about determining the law and fitting the law. And they are meant to scare you. They are meant to build on the fear that you're going to have somebody who's going to allow everybody, all the criminals, to run loose, or whatever the issue may be. And it is really disconcerting. When I ran, it's a million years ago, the purpose of the fundraising that went on in a campaign was really to get money from both sides. Was money to get from the defense and the prosecution, from business as well as the plaintiff's bar. And that was a sign that you were a good candidate, that people across the board were willing to come into your court and hear the decision. That's not true anymore. Now, tens of millions of dollars are going to be put into this race. I've heard as high as $40-some million. Recently, there was over a seven-figure buy for one of the candidates. And so, that kind of money is really designed to have you not look at the qualities of the individual justices, but to be afraid and to vote for another candidate. So I would look to see who's sponsoring the ad, what the subject matter is, and it doesn't have anything to do with either the candidate or the court.
Professor Schwaber, do you expect outside money in particular to be a big issue in this race?
Oh, absolutely. And I just cannot enthusiastically enough endorse everything that Justice Geske just said. Part of the problem, and this is not only true of judicial elections, is that the way money can influence an electoral outcome, as Justice Geske just said, I'm repeating, is through primarily television advertisements. As a medium of communication, television advertisements are not well suited to careful discussions of complex legal issues, nor would most voters get mobilized by those things. So instead, we have this demagoguery and scare tactics about things like crime being put up on ads by organizations whose real concern is the corporate tax rate or some other thing. It can be almost anything. And so I couldn't agree more. I saw a study once that is years ago that has stuck with me ever since. Someone compared criminal sentences handed down by local judges across, I believe it was in Pennsylvania. And what they found is that during election years, judges handed down more severe sentences regardless of whether their district was liberal or conservative, because the easiest way in the world to challenge a judge is to claim that they're soft on crime. Soft on crime is just the cheapest, easiest gimmick, and also the least relevant most of the time in any kind of judicial election. So in order, for fear of diminishing their chances of re-election, these judges, even liberal judges from liberal districts, were imposing more severe sentences when it was an election year, which raises the extraordinary, and I hope shocking, proposition that if you're a criminal defendant, you better worry about whether you're going to trial in an election year or not. So I absolutely agree with all those comments. The other piece of background I would add is that, part of this was the breakdown of the idea of nonpartisan courts. once you had, in the case of Wisconsin in 2008, and different states have different stories, but in the case of Wisconsin, Wisconsin Manufacturers and Commerce played a key role in this. Once you had the realization that succeeding in getting the right person on the court could really benefit your organization, your interests, it became politicized. We're now at the point of essentially finding candidates on spec. That is, large-scale funding organizations coordinating, sometimes illegally, with local organizations and parties are saying, go find me a candidate who will support XYZ. And I'll fund that candidate. They don't care who it is. And they don't care what else that candidate is about. And then the parties go and find a candidate who fits that specification and come into all that money. It is a complete perversion, in my view, of electoral democracy in general, but especially the election of judges. So I agree with Justice Geske. If anything, perhaps I'm less temperate in my phrasing, but I really think this is a corruption of the process at a very, very basic level.
And Deborah, the league has been involved in efforts in recent years to educate voters about the judicial system and the importance of an independent judiciary and issues of judicial integrity and fair courts. You mentioned in your statement, your opening statement, that you did petition the Supreme Court. You wanted justices to recuse or remove themselves from cases that involve their campaign donors. Talk a little bit about why that was important to you or to the league.
It's been important to us for our history. In order to have independent judiciary, you need to have independent judges. And as the professor was just saying, when the process is corrupt, as it is today with all of this influence of outside money, we have lost the confidence that there is no conflict of interest from the justice who's hearing the case before them. In fact, I think many citizens now are leaning in the direction of believing the case is decided before a single oral argument is made in the courtroom. And we should not have courts that operate in that manner. Everyone should believe as they stand before a judge at any level of our judiciary that they will hear what is said in that courtroom. They will look to the law and to the Constitution to ensure that whatever ruling they put out are based there, and their own personal ideology will not influence their decision-making. And if going into a case, they believe that their own personal ideology might influence a decision, they should recuse or acknowledge that conflict of interest and take themselves off the case. And in the absence of any sort of ethical standards being set in Wisconsin, each of our judges makes that decision for themselves as to whether or not there's a conflict of interest. And when a judge, and these are kind of big bad words, but is bought and paid for by a particular interest, they have no motivation to recuse themselves because they're sitting in the chair to make the decision that some large donor or political interest has asked them to make with their money.
I want to move on to one other issue before we start taking some questions from our attendees. And please do type your questions in the Q&A section. I did notice a couple of questions that were about specific candidates and stories in the news, negative stories in the news about specific candidates. We're not really prepared to address those types of specific issues in this forum. We're looking at the broader issues. Let's talk a little bit about the Judicial Code of Conduct, Justice Geske. Is it violated if a candidate shares views on, for example, redistricting or reproductive rights? Is that a violation of the Judicial Code of Conduct?
Well, historically that was. The U.S. Supreme Court has had a couple of cases, one out of Michigan at one point, that indicated that it interfered with a candidate's freedom of expression. And I think, if you listen to candidates, I mean, there's one thing, and when I was running, this was an issue. People want to know where you stand on the death penalty. And my view on that was, I do have a view on the death penalty. But the minute I tell you what my view is, you think that no matter what the case is, that I will reverse it because that's my personal view. And really, the issue is, and I say this publicly now, I'm against the death penalty. If I were on the court, if Wisconsin had a death penalty case, and if I could not, under any circumstances, affirm a death penalty verdict, then I should recuse myself from the case because my own personal philosophy and religion or whatever it is keeps me from independently looking at the case. I have decided cases that were inconsistent with my political views. I have angered, that's what I think is an independent judge. But what's happened is we've even moved from people saying their opinion on an issue to almost how they would decide it. How would they decide gerrymandering? That's another issue we haven't talked about. How would you decide these cases? And so if there's a preordained vote coming in February and in April, then we don't have the independence. And I think it's probably no longer technically a judicial ethics complaint. I just want to mention one other thing. We've had problems with the issue. Again, it goes to the 4-3. We had a justice who, in my view, clearly violated the judicial code during an election. It had nothing to do with court decisions. The Court of Appeals generally found that there were lies promulgated, and the court divided 3-3 on proceeding on a judicial ethics complaint, so nothing happens because they're the last arbiter. So not only does it affect decision making, but it can decide. It can affect ultimately whether a justice gets punished for something that he or she has done out in the community. So anyway, I'm passionate about this.
Sure. Professor Schwaber, what about your thoughts on the judicial code of conduct and whether a candidate can talk about their views on controversial issues, yet maybe stay independent when it comes to ruling on specific cases that come before them?
Sure. So there are a couple of different dimensions here, actually. I don't necessarily agree, at least completely, with the other two panelists that a person's ideology is grounds for recusal, but certainly financial interest is. Certainly, if you have a personal, I mean, the most basic issue of judicial corruption has to do with, does the judge inquire with the justice, have a direct financial interest in the outcome? And by any code of judicial conduct that exists, the answer should be yes. And the case that Justice Geske just mentioned, I know that case. We're not naming names. I appreciate that, but it was egregious. And it was not something as subtle as, is this person's view of history or religion influencing the decision making? This was flat out old school corruption during and lying and conflicts of interests that were all financial interests that were involved. So before we even get to this business of should judges or just candidates for justice talk about their views on cases, we might ask for some bare minimum of ethical standards in the conduct of judicial elections and the conduct of the justices once they're on board. And the fact that those three justices really unmistakably, in order to shield their ideological ally, there was really no other explanation for it, declined to allow any scrutiny in that instance was appalling. The question about, should you answer how you rule on a specific issue? Justice Geske gave a great, again, description of the argument in favor of saying you shouldn't. You shouldn't, if you're a judicial candidate, say, elect me, I will always vote against the right to abortion, or elect me, I will always vote for, it doesn't matter which way it cuts, obviously, the right to abortion. The difficulty with that is if you look at US Supreme Court nominations in particular, in the last 30 or 40 years, that's become a dodge. There's a very strong case that at least two current members of the Supreme Court committed perjury when they were asked their views on particular issues and said things like, I've never considered that question, when they in fact had written about it or had long records of doing so. There's a line between the ethical obligation to avoid approaching a case, having prejudged its merits based on some personal commitment, and trying to disguise the program that you're bringing to the bench, in order to further, that very program. So I have a bit of mixed feelings about this. I would wish, to me, again, the problem comes back to the fact that None of the discussions we have in judicial elections have anything to do with the qualifications of judicial elections. Are you soft on crime? Are you for or against abortion rights? Are not the questions I want to hear. I would like to hear judicial candidates pushed to give an actual description of their judicial philosophy. How do they interpret statutes? How do they resolve conflicts? What is their view of separation of powers and the distribution among the branches in Wisconsin, which is kind of idiosyncratic among other states as it happens. The difficulty is that those are technical questions, which are not well suited to being publicly debated in the course of an election, let alone an election being conducted by television advertisements. For want of a better way to put it, the influx of partisan politics and money has dumbed down the process to the point where getting elected to a position on the Wisconsin Supreme Court no longer requires demonstrating any particular legal competence. And I don't want to go any further because we're getting, on people. When the process was more nonpartisan, the only question was, does this person have a resume? Have they had years of practicing law? Have they served as a judge? Do they know what they're doing? Are they a respected member of the community? Do they have good educational qualifications and that sort of thing? When the determination of who's a good candidate turns to ideology, are they on our side or not? You lose the ability to filter for judgment, which is supposed to be, of course, a judge's stock in trade.
Let me take a question from our audience. Someone wants to know, and I'll address this to Justice Geske. Could you give an example of a liberal or a conservative, actually a liberal and a conservative judicial philosophy position on a law or the Constitution?
Well, I'll use an example of a case I had, which was pretty narrow, but it was an issue that I think demonstrates at least what I like to think was my impartiality. When I was on the court, one of the issues that came in front of the court involved gay adoption and gay visitation. Now, this was many years ago, and fortunately, we've moved much beyond that. And the question was not so much a constitutional analysis, but it was a statutory analysis of whether the statute allowed for, whether the legislature intended to allow for gay adoption, that is the partner who is not the natural parent, or whether, and then the second case came along on visitation. And I was in the majority on the first decision to say that I did not believe the statute allowed for gay adoption at that point. I did write a dissent saying that I really wanted the legislature to look at this because I thought it was an important issue, but it's a legislative issue and not a court issue. There was no constitutional argument within the case. Shortly after, and I don't know how long it was, along came a question of whether the partner could, after the split, could visit the child. And we looked at the statute, and the statute said anybody who lived in a parent-like relationship with the child had a right of visitation. And I wrote, and I was with the majority on that part of the case. So the case went sort of the other way in terms of allowing for visitation by the partner, the non-parent partner, to be able to visit the child. Why is that important? Well, I hold that case up just because I had a lot of angry friends on that first case. And to the point that when I left the court many years later, I had some of my gay friends come up to me and say, can we go out to lunch? Can you tell us why you voted the way you did? And I went out to lunch and I explained that, part of the conservative versus the liberal, if you're talking about partisan, then you just say, what are the politics of the day? And, do you want to back what the Republicans are doing, or do you want to back what in our case, the legislature is doing, or what the governor is doing? But the conservative, liberal, or judicial philosophy is more, we've had this case on the books for, and I don't want to use abortion, 25 years. It's operated, the country has operated, the state has operated. There really is nothing that's changed. We give value as a judicial conservative, and I consider myself a judicial conservative in that box, not to be upsetting the law, not every term to have a new decision depending on who's on the court, because that creates chaos in our culture. People adapt to what the law is and can campaign and other things to change it. But to me, the judicial conservative is somebody who sticks to the barriers of what the court does versus the legislature and what the governor does. You know, I was part of majority that upset some of Tommy Thompson's campaign. He didn't like it. He didn't talk to me for a while. I see that as a badge of honor, not because I don't like Tommy, because I do. I have a lot of respect for him. But ultimately, my role was not to back Tommy Thompson. It was to look at the law and see whether we ought to be upsetting it, we ought to be changing it, and so that's really the difference of how a case fits into the stream of cases and law versus, you know, whose party is standing up for this issue.
Well, Justice Geske, you didn't want to use abortion as an example, but we do have a question that relates to this, and I can maybe have Professor Schwaber start on this one. Would the 1849 constitutional law related to women's reproductive rights be considered legal precedents? I believe she's referring to the statute that's on Wisconsin's books that would essentially ban most abortions, or does ban most abortions in Wisconsin since Roe v. Wade was overturned. This case is likely coming before the Wisconsin Supreme Court, as the Attorney General is challenging it. Our attendee wanted to know, how does this differ from the Roe v. Wade U.S. Supreme Court decision? Can you talk a little bit about whether that law that's on the books is considered a precedence, Professor Schwaber?
Well, that's not usually how we use the word precedent. Usually we use the word precedent to refer to a court decision from the past that interpreted something, it interpreted statute, it interpreted a provision of the Constitution. And over time, those precedents build up to become a body of judicial interpretations that gives a substance to the constitutional law in particular. It's less the case in statutes, although as Justice Geske points out, that's certainly part of the process there as well. So that statute isn't, in the usual use of the term, a precedent. The United States has a strange system in comparison to other constitutional democracies around the world. When our highest constitutional court, the U.S. Supreme Court, rules a law unconstitutional, the law doesn't go away. It's only that judges, state court judges specifically, are prohibited from enforcing it. We have a standard political practice in this country of legislators passing laws they know are unconstitutional in order to have them struck down by federal courts so they can then campaign against the court in their next election cycle. This is a well-honed strategy that builds on this quirk of our way of doing things that most constitutional democracies do not. The result is that when something like Roe versus Wade, which was the case that said that there is a right to abortion, right? So with various restrictions upon that right. But when that case declared laws like the 1840s Wisconsin statute unconstitutional, those statutes didn't go away. They just became what you might call dormant. And so as soon as Roe was overturned, they came right back into effect around the country. Nowadays, legislatures are even passing what are called trigger laws. Laws that say this will take effect as soon as the U.S. Supreme Court says it's constitutionally permissible, that it may take effect. So the whole system of legislation in response to judicial decision and the interplay between those two branches has become a rather gameable, or rather gamed system in our country and in our state. And that's what's going on here. If I could follow up on Justice Geske's comments, two very quick points. I know I'm taking too much time. One, I always like to say, if your judicial philosophy or your approach to interpreting the Constitution always leads you to conclusions you approve of, you don't have a serious philosophy interpreting the Constitution. And two, the difference between judicial liberalism and judicial conservatism, not the policy version, does have to do with deference to existing precedent. It has to do also with levels of generality. How much do you read a text, whether it's the statute or a constitutional provision, in a way that will achieve what you believe to be its purpose? And how much do you read it technically in a way that will bind the actors? How much should courts cooperate with legislators in trying to achieve whatever policy outcome the legislature has in mind? How much is it the job of courts to keep legislators honest, so to speak, by making them fix the phrasing until there's no way that clever lawyers can find a way to usurp the purpose? Those kinds of questions, rather than which party do you support, are what judicial philosophies of liberalism and conservatism are really based on. And of course, the role of history and originalism and all those other debates, but none of those things dictates a policy outcome. You can make an originalist argument for any policy outcome that you want on any particular issue, and you can make a non-originalist argument in the same way. There ought not to be any direct correlation between judicial philosophy and case outcomes at all.
Well, I wish we had more time, but we're already running short. Perhaps we can have each of you give us some closing remarks from your perspective about why the race for Wisconsin Supreme Court matters, and why voting in the primary on February 21st and the spring election on April 4th matters to all of us. And maybe if you have them, ways people can make up their minds on this important race. Deborah, why don't we start with you?
Thank you. I think I would just let everyone leave this event thinking about what this court will decide in the future, what types of cases will come in front of this court, and what values do they share with the justice that they want to elect in hearing those cases. This court might actually hear arguments for judicial recusal. They may deal with education policy in the state of Wisconsin. Obviously they're going to see women's rights, economic development, voting rights, labor rights. All of these very important to our daily life issues are going to come. And we just have to make sure the justice that we elect represents our values and not the values of the money or the political parties.
Justice Geske.
I would just encourage everybody to read and watch as much as you can in terms of what the candidates are saying. They're talking more than they ever have before. And I am concerned when I hear somebody's a reliable vote for a party. And to show you the chaos that it can create, if you have, for example, a court that is backing Democrats, and they take away a Republican governor's ability to do things, there's going to be an election down the road, and then it's going to flip. And so are we going to flip the law, and are we constantly going to have that chaos, or are we going to establish well-established law? I would look for people who talk about reliability in decisions, just for the reason that Howard talked about it, that the fact is you want somebody who's fair and impartial, and sometimes they're going to call the case inconsistent with their supporters.
Mm-hmm.
And Professor Schwaber, last word.
I get the last word, goodness. Do not learn anything from television advertisements. If I could do one thing, if I could, make one thing happen, never accept anything that you hear on a television advertisement. Go read interviews, go read statements. If you're really industrious, you can go read cases if you like, or articles or whatever there is out there, but not the television advertisements. They are by definition misleading. It's obvious I have a rather dark view about what the Wisconsin Supreme Court has become over the last decade and a half. Perhaps in addition to focusing on issues and values, it would be great if voters would focus a little bit on the question of, is this a candidate who, if elected, will help restore the integrity of the institution? Because I think that's a concern separate from specific legal and rights issues that we've been talking about, that in Wisconsin is a matter of some urgency.
Well, I thank you. Thank you all for being with us. We will post as much information as we can in the chat before we completely conclude. Remember that the primary is on February 21st, that the general election or the spring election is on April 4th. We have some questions asking, will there be debates? I don't know specifically, but I assume there will be among or between the two top vote getters from the primary. You can get a lot of information on Vote 411, which will be coming out with a fresh new edition next week. That's from the League of Women Voters, Vote 411. You can get a lot of information on My Vote, the Wisconsin election site. So please do that and keep following these issues. Thank you to all of you for being with us. Deborah Cronmiller is the Executive Director of the League of Women Voters of Wisconsin. Howard Schwaber is a UW-Madison Political Science Professor. And former Supreme Court Justice Janine Geske is also a Marquette University law professor. Stay with us, though. We have another few minutes to learn about and to congratulate the recipient of the next $1,000 Madison Civics Club Youth Grant. It is a part of our mission to encourage and celebrate youth civic activities by awarding these grants and to help in these efforts. Today, our youth grant goes to Vel Phillips Memorial High School in Madison for its Med Life program. We have with us Greg Maurer, the faculty advisor of the group, and 3 of the students involved in the group are also with us. Let's see if we have them all up with us. I am looking. Yeah, there he is. Hi, Greg. Thanks very much for joining us. We'll start with you. Please tell us about what your group does and how you intend to use the Madison Civics Club grant.
Happily. Thank you very much. Good morning. Excuse me. Members of the Madison Civics Club, our esteemed guest speakers, and anyone else who might be joining us today. My name is Greg Maurer. I've been a history teacher at Vel Phillips Memorial High School for 4 years and a teacher in the Madison Metropolitan School District since 2014. Previous to that, I spent several years working as a political appointee in the Wisconsin State Capitol, serving primarily in the role of constituent caseworker. I bring this up because I understand the importance of healthy civic dialogue and the need to promote an educated and engaged citizenry if we hope to maintain our very precious democratic institutions. So with that in mind, I want to extend a sincere thanks to the Madison Civics Club for their commitment to those values and the support that they provide to our community as we weather a uniquely divisive time in our society. Your contributions, time, and attention genuinely do make a difference.
Thank you. Well, what tell us about your efforts with MedLife and what you hope to accomplish with the grant.
Absolutely. So I'm here this morning to speak about a group of young people who are not only taking on their personal educational and civic responsibilities, but are also additionally seeking opportunities to benefit local, national, and global communities through our student-led club at Memorial High School, MedLife. So MedLife is part of a larger nonprofit organization that works to make healthcare more accessible to low-income communities around the globe, including in Ecuador, Peru, and Costa Rica, by fundraising medical resources and mobile clinics. MedLife is also organizes service trips where chapter members can travel to developing nations to participate in projects related to housing and infrastructure. MedLife stands apart, though, from similar organizations due to their focus on provision of care by local medical and social safety net providers who do not depart the community at the end of the volunteer trip. So MedLife functions internationally to raise awareness of medical concerns afflicting underserved communities, educating member groups on pressing medical and social developments, fundraising for related causes, and of course, offering service learning trips for high school and college students. However, our MedLife officers, Olivia Ju, Sanjay Palta Hill, and Arina Vodjanik, are joining us this morning and have sought to reduce the impediments experienced by many families and individuals in the memorial attendance zone as they seek to acquire basic living essentials, such as food, clothing, and toiletries. So while systems of support do exist, frequently anyone accessing them must work through application and qualification screeners, or they might be at the mercy of available resources stocked at our school. And so the generosity of MCC will allow MedLife's project of expanding and supporting memorial services provided by the Student Services Office, helping students and families receive any resource they need, such as food, clothing, transportation services, school supplies, and hygienic products. So the Madison Civics Club grant will be applied by MedLife for purchasing gift cards, resources, and items for students and families who express a need. And this will fill glaring holes in the availability of basic necessities for members of the memorial community. And so it has been a fantastic pleasure to advise our MedLife officers throughout this year and previous years And I will now cede the floor to allow Olivia Ju, Sanjay Paltahill, and Irina Vodyanik to offer their perspectives on what MedLife has meant to them. So thank you all very much.
Wonderful. How impressive. And we're so, the Madison Civics Club is so honored to be able to help in this effort. Let me ask our students who are with us today to go ahead and unmute, and let me just ask you one by one. Sanjay, why don't we start with you? Why did you decide to join MedLife, and what are you gaining from the experience?
Well, I think that MedLife truly gives students a better global education. I actually didn't know about MedLife until last year when I had my own personal medical issues. I needed emergency surgery to find a spinal tumor. And there's a series of tests that revealed this, such as MRI and mainly MRI. But I joined MedLife because I was interested in learning about how these issues are treated in people who may not have access to magnetic resonance imaging or high cost, hard to acquire resources like that. And so I think this year we've fundraised, yes, but I think we also learned about how do we think from other people's perspectives, and how is healthcare handled differently in different places around the world. And I think that by understanding that the healthcare system isn't fixed and set in stone like it is here, that there are different ways to approach healthcare based on resources and societal views. So I think MedLife really does make us all better global citizens.
Thank you very much, Sanjay. Let's go next to Olivia. Why do you think this effort is so important, and what are you getting from the involvement?
Yeah, so I initially joined MedLife because I heard of its activities during its first year. And as Sanjay mentioned, there was a lot of fundraising going on. And during that first year it was running, there were a lot of food drives, and there were a lot of informational sessions. And so I joined because I thought I would be able to learn more about healthcare, not just in the United States, but just all around the world. And I have. So this year I was able to learn more about the different barriers to accessing healthcare in different countries. And so in regards to this project in particular, I think it's really interesting to learn how there are multiple factors that can affect people's access to healthcare, such as food security and housing. So that's just what I've been able to gain so far.
Thank you. And next, Irina, tell us about your involvement and why you think this is important.
Hello. So I joined MedLife because I really wanted to try something new. My parents, my mom, she has a medical degree, and I think I really underestimated how, I guess we are very privileged in with our healthcare system. And even though, yes, we have debates about our healthcare system, I think I realized I really took our opportunities for granted in this country. And my parents themselves, they're immigrants. I kind of grew up, my parents taught me you have to take everything, you can't take everything for granted that we have. So why I like MedLife and why I joined it is because I wanted to try something new in the healthcare industry, and to see how I can help other people across the globe, and how I can teach myself that, not everyone has the same opportunities as you, and you have to look at that and help others. And I think I just wanted to see and expand my vision and my knowledge of outside of my comfort zone, outside of what I've seen, and just I want to see how things happen on the global scale. And that's what really interests for me personally.
Well, I want to thank you all for being here, and thank you all for your involvement in this and your service and all the work you do. The check is in the mail. We will look forward to seeing the fruits of your labor. Thank you so much for being with us. If you know of a school or a community youth group deserving of a grant to continue a civic project, please let us know. There is an application available on our website, MadisonCivicsClub.org. Our next Madison Civics Club program is scheduled for April 29th, the last Saturday in April, I believe. We are planning on that program to be in person. We are looking at having it at the Fluno Center on the UW-Madison campus, and going back to that traditional buffet brunch that we used to have before the pandemic. And we hope we will have speakers addressing education issues, perhaps civic education efforts in Madison. If we can learn about more civic activities that are going on in Madison area schools. We're still working on that, but you can save the date, April 29th. We will send you an email and post about it on our website and social media when it's all set up. On behalf of the Madison Civics Club, thank you so much for joining us and for caring about all of these issues, including Wisconsin Supreme Court matters. Hope to see you in person next time. Thanks for being with us, and be safe out there as